It's now my great pleasure to introduce the second speaker in this panel, and that's David Bilchitz, who is a professor of fundamental rights and constitutional law at the University of Johannesburg and a professor of law at the University of Reading. David is also the director of the South African Institute for Advanced Constitutional, Public, Human Rights and International Law, and he is vice president of the International Association of Constitutional Law. David is a director also of Animal Law Reform South Africa and has been involved actively in changing the plight of animals there. He's also written several articles, as I'm sure many of you will know, considering the changes that the new democratic constitutional order, which emerged in South Africa in 1994, should bring about in relation to the status and entitlements of animals. And today in his talk, he's going to explore the institutional dimensions of what it would mean to take animals' interests seriously in a democracy such as South Africa. David, thanks a lot for being here.
Thank you. Thank you so much.
It's a clicker here if you need it.
Okay, brilliant. Thank you very much and greetings, everyone. I just want to say thank you to Raphael for the invitation and how tremendously exciting it is to be here. Often, I think those of us working in animal scholarship, perhaps particularly in places like South Africa, feel rather marginalized. So it is nice to be in a group of people who don't think we're totally crazy. And yes, it's also been, my head has been in the space of working on a book on business and human rights, which is about to come out. And so it was a wonderful invitation to actually start thinking about, again, an issue that I had flagged for attention, and this conference provided me with the opportunity to engage a little bit more, though the paper still needs development, and I'm looking forward to the discussion afterwards. So I'm going to start off with a very fascinating and important case. Some of you may be aware of it, called the NSBC case at the end of 2016 that was delivered by the Constitutional Court in South Africa. The judgment concerned the witnessing of the slaughter of 2 camels in a terrible way. Multiple cuts were done against the camel, and eventually the SPCA came in and shot the animals, right? And they wanted to press charges of cruelty against those who perpetrated the abuse. The National Prosecuting Authority declined to prosecute, even though it has the legal basis to do so. And the question then arose of whether the National Council of the Societies for the Prevention of Cruelty to Animals could conduct private prosecutions to hold to account those committing animal cruelty when the National Prosecuting Authority declines to prosecute. South African criminal law procedure allows, in some cases, private prosecutions. The Constitutional Court found that it could, and did so through an interpretation of the statutory powers of the NSPCA. I will refer to it through the acronym in this talk. In the course of its judgment, the Constitutional Court made a number of important findings about, firstly, the reasons for protecting animals and the roles of the NSBCA in the society. The court starts the judgment recognizing a shift from regarding animals as mere brutes or beasts to their recognition as companions, friends, and brothers. I don't know why not sisters too, right? Later it charts the development in law of the rationale for protecting animals. Initially it said animal cruelty laws were prohibited to protect the finer human sensibilities and preventing the degeneration of finer human values. This was early case law of other courts. Gradually, the court says, the other courts started recognizing that animals are worthy of protection because they are sentient beings, capable of suffering and of experiencing pain. This was a minority judgment, and later on, judgment dealing with rhino poaching held that the new constitutional order had ushered in a more caring attitude towards fellow humans, animals, and the environment in general. The court then reaches a far-reaching conclusion, perhaps one of the most progressive in the world. It says the following: the rationale behind protecting animal welfare has shifted from merely safeguarding the moral status of humans to placing intrinsic value on animals as individuals, right? Almost recognizing dignity of animals, right? By the use of intrinsic value in South African constitutional law is very much linked to the notion of dignity. It also finds a constitutional status for protection of animals in the environmental right. It had to find a route for the protection of animals, and it finds it in the environmental right. I'm happy to say that some of my work, although not cited by the court, played a little role in this. Saskia was at the actual workshop. I presented this paper about the link between the environmental right and the intrinsic value of animals. And the court, some of the researchers of the court heard the paper I presented in South Africa, and I was told by a number of researchers that this then was used as the basis to create this link, which has now fundamentally changed South African environmental policy from a complete, what they call sustainable use framework, which ultimately is a use and exploitation of animals framework, to now starting to say we have to integrate a recognition of animal welfare into our conservation policies. And if those of you are interested, I'm happy to discuss with you. This is very exciting, groundbreaking things that are happening at the moment in South Africa. Now, the court goes on from these important recognitions to move on to the institutional implications of what it says. And it says, to protect our voiceless companions, the court references the fact that individuals have time and again stepped in when animals are mistreated. From this basis, it recognizes the need for a specific institution to protect animals, and it references the fact that around the world, societies similar to the NSBCA zealously defend their welfare. These organizations, it states, champion the norm that we do not accept acts of cruelty against those who cannot defend themselves. It charts the history of the initial formation of various societies for the prevention of cruelty to animals. This, of course, structure is not unfamiliar to people in the UK. This was the origins of that structure. In 1993, the legislature passed a special act, centralized the SPCAs under a national council, which is subject to ministerial oversight. The NSBCA, the court concludes, came to be seen as the special guardians of this laudable norm, and it entrenched the position of the NSBCA. The court says the NSBCA is a public body with wide and singular responsibilities in this field, and its singularity is that it is tasked with preventing the ill treatment of voiceless beings. Its long history of guarding the interests of animals reflects, it says, constitutional values. And it says it has taken on the role of protecting animals in all our interests. Okay, it then reads the act purposively to grant prosecution powers to the NSPCA as they are required to perform this role. Now, this is a wonderful judgment in many respects, okay, and slightly surprising the court didn't have to go into certain aspects, which it did go into, and it provides the grounding which organizations like I'm involved in, Animal Law Reform South Africa, are now trying and draw out the implications of what this means in practice. Okay, because there's still terrible abuse of animals throughout South African society, and we're trying to think of how to encourage the courts to utilize these statements to give actual concrete protection for animals. But the Constitutional Court has, as I said, positively affirmed the change in the status of animals. It also articulated a strong and powerful role for a particular body and empowered it in specific ways. This is this NSPCA. The missing link, however, and this was the initial impetus for the paper, was a deep engagement by the court with whether the NSPCA is properly set up to be able to perform this role. It essentially empowers a body without examining its fitness for purpose. Okay? And just as an aside, I'm not meaning to attack the SPCA. Does many good work, a lot of good work, the NSPCA as a whole, but there are tensions around its role and various issues that have arisen for those people working in animal protection. And so those things are in the back of my mind when thinking about these issues, okay? And it raises ultimately wider questions about how to constitute an institutional structure to protect animals. So to address this question, I'm going to proceed in two stages. I like generally to link the theoretical and the normative and the practical and the institutional, both which help to inform one another. In the first part, I'm going to look at the question, I'm probably going to spend most of my time on that. How should a public body be set up that seeks to defend beings with inherent value that are sentient but cannot participate in democratic structures? Okay? And the second part, I'm going to turn to the concrete example of the current structure of the NSBCA in South Africa, its relationship with SPCAs, and evaluate them against those normative standards. As I said, I'll do that in relatively briefly. This is a large research project, obviously. I know that many people are working on governance around animals. I found relatively little about SPCA specifically, interestingly enough. I would look forward to engaging with the ideas in this regard. And of course, if people know of things that I've missed, I would love to hear about that. So if animals are just property or things, there is no need really to think about their interests and how they are protected. They will be valuable or could be valuable instrumentally, and we may confer protection to protect our interests in relation to them, right? And this is often relevant to parts of the environment. Once we recognize that they have interests which are serious and worthy of protection, that they have, in other words, inherent value, and they are members of our own community, and that members of our own community threaten those interests, then we need to consider what structures are needed to ensure respect for those interests. Protections in society are not only focused on others who have reciprocal duties, which we've just heard about in many ways, and that is other adult humans generally. Our protections in society include human beings such as young children and those with severe psychosocial disabilities who are not capable of reciprocal duties. So one approach would be to adopt what I call the analogical approach. Consider the position of animals as analogous to these groups of human beings, and consider how our society approaches their protection and which institutional structures are formed. That has the benefits of, on the one hand, highlighting the similarities between animals and humans, who are often seen as the focus of legal protection, and linking animal protection institutions with those around which there is already much thinking and development in relation to humans. However, there are two problems too, right? On the other hand, whilst there are similarities, animals are also in many respects differently situated. And I think we have to think very seriously about that. I think we may have some engagement more about the last two talks that I'm sorry I wasn't able to attend this morning's, but that I think we need to grapple with the difference of animals as well, right, in many ways. Young children will generally grow up into obviously adults capable of reciprocal duties, and a healthy animal is different to a human suffering from a psychosocial disability, right? And so we may fail to capture the particularities of animals, and I think that's really a challenge for us to think very seriously about the differences amongst animals and with deep respect capture their differences too. Moreover, in many cases, the institutions that are developed to address these categories of humans are in fact full of shortcomings and insufficient, such as the recent questioning around institutionalization for those with psychosocial disabilities. An analogy relies on the sufficiency of the institutions which are the focus of the analogy. If there is something deficient in relation to the human case too, then there will be very limited guidance. It does not answer the foundational question of why we should structure an institution in that way. So I'm not knocking the strategy completely. I think there's a great research project to look at pursuing the analogous strategy in some detail, but for the reasons given, I'm not going to adopt that approach. I'm rather going to adopt what I call a purposive functional approach. They're very similar. Purposive approach seeks to examine the foundational underpinnings of any institution based on the purpose it will serve, and a functional approach considers the makeup of the institution in relation to its purpose or function, and it includes both normative and practical dimensions. So I have to show you what this all means. So step one is we need to start with the nature of animals. We've already talked about the fact that animals are a vast group with wide-ranging differences. We may need to contemplate a differentiated theory like Kimlicke and Donaldson offer us between types of animals with similar characteristics and different relations. But while there is much to commend the strategy, I want to focus in this paper on the commonality that exists across all animals, that they have lives of their own, but their interests are extremely vulnerable to the exercise of human power. And human technological power ultimately grants us almost complete mastery over the animal kingdom. Moreover, animals, despite their vulnerability, are not able themselves to play a role in our political communities to decide how their interests are to be defended. Humans make decisions all the time which affect their interests without their having a say. In general, they also lack a direct relation to political power in the way that differs from groups of vulnerable humans. As I've already said, children have parents, and those with psychosocial disabilities usually have human families. Companion animals, particularly dogs, cats, and horses, may have more familial type relations with animals, yet even there's a difficulty of understanding fully their needs and wants. Animals used in agriculture and wild animals often lack such a connection. Given their vulnerability and their lack of political participation, how can their interests be protected and through which medium? Now, there are many elements to this issue, and I know some of you are working on the first question, which is the question of political representation. Kimlicke and Donaldson argue that companion animals should be regarded as citizens of a kind. That is an ambitious argument which is extremely interesting, and if that argument's accepted, it will have significant institutional implications, and I think they are fascinating to tease out, right? However, I'm going to focus on another question, the question of protection. I want to focus on the makeup of institutions that protect a more minimal set of guarantees for animals, to ensure their most foundational interests in bodily and psychological integrity are not abrogated, and to respect the basic conditions for their flourishing. In other words, the question is normatively how to design institutions in a way to ensure human society respects these most foundational interests of animals. Now, the SPCA model, which I call it, is the idea that given animal vulnerability, there is a need for specific institutions to protect them without which their interests would be lost. You can think of another kind of argument that these should all be integrated into existing institutions. I think there's a good argument why we need a specific institution in this area, in that animal interests are likely to get lost, I think, right? But once we think about setting up specific institutions, the question becomes who then is entitled to defend or protect animal interests? What principles should determine how they are set up? And as I said, I'm going to adopt a purposive approach. So the starting point for institutional design must be the goal of the institution. And such a goal must start with recognizing that every animal has intrinsic value and is to be treated in accordance with that value. That requires, at a minimum, to ensure animals are protected against violations of their biological and psychological integrity and provided with the general conditions necessary for their being able to flourish in their own terms. These normative principles need to be at the heart of any such institution. Recognizing these as the basic principles, what would such an institution look like that seeks to realize them? I'm now going to go into a number of principles that seek to give effect to this purpose. So who should lead such an agency, for example? Such organizations will involve humans acting on behalf of animals. In this sense, they act as animal advocates, as I call it. Given this role, there is a need to ensure that the individuals involved in such an organizations are committed to that purpose. And here we need to have some indicators of eligibility. And I suggest the following: people with a history of concern for animals and their welfare, people with expertise concerning animals and their welfare or interests, people who show a willingness to change their behavior in respect of animals, many of us refusing to buy fur, become vegan, etc., and people who are not involved in industries that are abusive or controversial in relation to animals. There cannot be a conflict of interests. Now, one of the problems here that we face is disagreement. There will be many individuals who meet these criteria, and given essentially this role involves acting on behalf of animals who cannot act for themselves, inevitably that involves taking a view about what animal interests are and how to advocate on their behalf. Given the imprecision of humans acting on behalf of animals, there are bound to be disagreements amongst animal advocates in this regard. Indeed, this is not merely a theoretical possibility for those of us working with animals, and they're borne out by serious disagreements that exist amongst animal protection organizations. Is it kinder, for instance, to a companion animal that cannot be rehomed to be euthanized or to be kept alive in a shelter indefinitely? Does one try to work with exploitative industries to improve the conditions of animals therein, or campaign to end those industries? These are just some of the questions that many of us face. And disagreement, as I argue, may not be a bad thing in this sphere, and in some sense should be embraced given the difficulty of acting on behalf of others whose interests are not fully known. Despite disagreement, there is a need for decision-making in order to effectively advocate on behalf of animals. So I suggest the following principles. The first is there needs to be an openness to multiple voices of animal advocates. We need to embrace democratic decision-making processes and open policy-making processes. Now, open policy-making processes come with risks because it opens the door to exploitative industries to manipulate such agencies. And to avoid capture of such an agency by particular interest groups, it will be necessary to have criteria for leadership and processes for changing leadership regularly and term limits on tenures. There will also be a need for some decentralization across any agency, which allows for challenges to improper exercises of authority. This comes to look like, in a sense, the project that John and Raphael are developing around building some general constitutional principles into the very design of these institutions. Moreover, any such agency, I argue, should be required to engage in cooperative relationships with civil society, advocating for animal welfare. This would involve mandates to consult and engage with such organizations. There have to be restrictions on the abuse of power. right? Animal interests as the goal must be primary. Therefore, it's necessary to ensure that an organization isn't dominated by one person or a group of persons who may come to act in their own interests and not the interests of animals. Again, I think this is very importantly leads us to think about term limits for both board and professional leadership. Though there's a big challenge here in that in SPCAs, for example, you want also to have experience and continuity. And so you have a very big difficulty in that sense. Okay? Similar points apply in relation to the insulation against political interference for such a body, without which it cannot perform its function. The agency should have its independence, and appointments should not be based on political parties that are in power at any time. In a sense, I argue that such an agency should be conceived of as a fourth branch of government, along the lines of a Human Rights Commission, for example, and guarantees be put in place to insulate it from political interference. Individuals in such an agency should be required to act without fear, favor, or prejudice. What else do we need? Transparency is a vital part of such an organization's work to ensure it can be held to account in fulfilling its mandate. Individuals should have a right to access information about the activities of such a body, as well as its decisions and its justifications for those decisions. In terms of accountability, it is vital that such an agency understand itself as accountable to the political community in which it operates concerning how it performs its functions. Should it, for instance, have a duty to report to Parliament? I think it probably should. To this end, there is a need to provide reasons when requested to do so for any decisions which can be challenged. There need to be regular reporting requirements on its activities, including controversial decisions and the reason it takes for those decisions. Where controversial decisions are taken, there needs to be the possibility of reviewing or appealing the decision to an impartial body. And ultimately, I believe there needs to be a judicial review over the activities of such a body with a degree of deference shown, given judges may not be have expertise in animal welfare. And I think we also need to think about how judicial training needs to change, because we often see judges very unsympathetic. Another central question is how such a body is to be funded. Many current models effectively provide little public funding to such bodies. In my view, that approach is unjustifiable when we recognize animals as beings deserving of respect in their own right. The political community should not be conceived as being concerned only with human interests, though humans will be the main participants therein. All those who have intrinsic value and are vulnerable to the exercise of human power should be protected against abuses of that power. Guarding against such abuse is the responsibility of the political community, and consequently, in my view, any agency or organization established to this end should be funded by the political community through the national budget. Doing so simply grants to animals what they deserve as beings that share a territory with us. Inevitably, this will require some redistribution of resources from human beings. Often people don't like this corollary of what it means, okay? And in my view, we should defend that as being just, given the need to respect animals themselves and ensure they are protected against the harms that humans may cause them. So, the discussion thus far has identified the purpose of a public agency designed to protect animals. Flowing from that purpose, I've identified various elements that are desirable to ensure it can adequately perform its function. This discussion is useful in establishing normative evaluative criteria against which existing institutions can be evaluated. And so I'm now relatively briefly, I know I've already gone fast, so I apologize because there's a lot in here, is to look at the SPCA model in South Africa and evaluate some of its elements. Okay, I won't go through this, or you can come to me afterwards of what the kind of research I did and the constitutions I looked at, etc. The goal of the SPCAs, as they are at the moment, says it states that their goal is to prevent the ill treatment of animals by promoting their good treatment by man. This is okay, but it doesn't reflect really the shift in SPCAs to work in recognition of the intrinsic value of animals. Okay, and that rationale, I think, needs to be recognized. There's an overarching structure. Ultimately, there are local SPCAs which have a membership and their own roles, and they have a management committee of between 5 to 10 people who are elected by the members. The National Council is a membership of the societies and directors. And the management of the board of the National Council, I won't go through this in detail, but it's directors from the various societies across the country, plus one director appointed by the minister and the executive director. Right? Membership is ultimately vital because it determines who the leadership is, right? And so who is a member is very, very critical. Okay, and I'll talk to you now about that. Ultimately, an ordinary member pays a fixed amount. Ultimately, you just come to the SPCA, you pay an amount, and then you're a member. A corporation can also nominate someone to represent them. They can then attend the meeting, and they're eligible for election, right? There's an interesting clause in some of the constitutions. No member of the governing body or staff shall be a member agent of another animal welfare organization. Okay? There are some basic protections against conflict of interest as well. So, as I argue, any person who pays a fee, there's no guarantee that that will be people who have animal interests at their heart. And so how do we achieve better criteria? On the one hand, you want to widen as far as possible people who are interested in animals, but you also want to guard against abuse of animals. So this is very difficult, right? It's not simple. There is an ability to exclude a person from being a member, but it's not clear what the criteria are and on what basis that is, and sometimes could it be just having a different view of what animal welfare requires. Okay? So there are some dilemmas there as to promoting wider membership, but worry about granting people membership who don't have the interests of animals at stake. Okay? In terms of management, the local SPCAs, the only requirement is that the person provide a one-page CV. And clearly this suggests there are some criteria, but which? Okay, that's the question. Management in terms of a rule of the NSBC must be open only to people who have become inspectors. So they therefore have to have some expertise. But it's also not clear that this necessarily picks out always the right people. There's no requirement showing that people in this respect do not exploit animals. Veterinarians, sadly, many of them are highly involved in exploitative practices. So we can't say expertise per se is a guard against, actually indicates necessarily that one is interested in animal interest in their own right. Okay? There are, as I said, basic conflicts of interest provisions, but I have a real problem with the provision that talks about conflict of interest being one with having a membership of another animal welfare organization. And essentially what it does is it writes a conflictual relationship into the SPCA movement with other animal organizations. And in my view, there should not be a competition here, and this is talking from the ground. This has often been the case, right? I don't know what it's like in Britain, but this is often the case in South Africa. Okay, there should be common objectives and there should be ability to work together towards common goals, and there should be a thinking about the relationship between the various voices. Okay, there is a problem with term limits. There's also a problem with professional leadership term limits, and I've already mentioned to you some of the issues over there. There's also been a centralization after the creation of the National Council, where essentially the National Council has wide. It used to be a very decentralized movement of the local councils essentially having their own domain. Now it was centralized into a national council which can have wide powers to make rules and enforce compliance. Okay? And that has a benefit of creating a coherence across the movement. It has a benefit of being able to lobby on behalf of the movement for animals in legislatures. So there are many good sides to that as well. To take big cases, one of them at the moment, which has so far unfortunately been an abject failure against the development of a live export industry in South Africa, which I've been involved with, and it's traumatizing to see what's going on in South Africa at the moment with that, but nevertheless, the SPCA tried to take that on as a whole. It's so far been unsuccessful in the courts. Ultimately, but it also has a great disadvantage. It enables a control by a group of individuals and a marginalization of diverse voices. What about funding? The organizations are provided no state funding in South Africa. All the funding is private, and this allows a capturing by private interests and also focuses a lot of attention on fundraising. Okay? So, and I don't think it's just for society set up for the protection of animals to be focusing on that and also not have funding from the national community itself. What about accountability? There's a lack of engagement generally with wider public accountability. As I said, there should be a duty to cooperate with other animal organizations, a duty to provide informations and reasons where required. There is actually general requirements in South African law to do that, but there actually need to be more specific requirements there, and a possible duty to report to Parliament. Lastly, on controversial decisions. Where there are controversial decisions surrounding animals, at the moment it's not clear how those decisions are made, and ultimately a few people seem to be able to make those decisions. Right? There ultimately, in my view, needs to be an open policy-making process, encouragement of submissions to be made from different perspectives, and not to marginalize people because of differences, providing an outline of reasoning, providing an opportunity for rethinking decisions after several years, and also the possibility of providing an avenue of an appeal, right? And we again need to think through all these kinds of issues of institution building. How do you create an appeal structure? Possibly a special committee constituted with experts on ethics and philosophy around the protection of animals, right? That perhaps betrays my own biases, but nevertheless, we need to think a little bit about how to constitute an appeal structure and the possibility of judicial review. So, in short, we are in the early days of thinking about the governance structures necessary to treat animals with the respect they deserve, right? I've tried to outline for you what I've called a purposive functional approach and various principles that can be used for designing such structures. I've tried to show some of the South African structures and their shortcomings. I know I did that very quickly, but just to give you a bit of a flavor of the empirical and the practical dimension as well. I think there are many issues for further research. Some of you might want to take them up. The philosophical underpinnings, there's a lot of interesting issues over here. Comparative institutions across the world, and I know some people are involved with that, and wider questions of animal representation, which I know people here are involved with. Ultimately, the goal of this research is to contribute to creating structures that truly help to protect and advance the interests of animals. So thank you very much.